Let's learn more about the choice of law provision in a disability insurance policy. Choice of law provisions in the policy. If there's a discretionary clause in the policy, you have to determine if the policy has a choice of law provision. A choice of law provision will tell you what state law is applicable, and that can make all the difference in winning or losing your case. Let me tell you about the case of Ellis versus Liberty Life. It's a 10th Circuit case that just came out. Ellis challenged the denial of his claim. He was employed by Comcast. He lived in Colorado. There was a discretionary clause in the policy that said Liberty Life's denial could only be overturned if there was an abuse of discretion. The case went up and down in the courts, and ultimately the 10th Circuit decided that Colorado's ban on discretionary clauses didn't apply because the policy had a choice of law provision. The choice of law provision said that the policy was governed by Pennsylvania law, which doesn't prohibit discretionary clauses. So which law applied? Was it Colorado? Was it Pennsylvania? How many of you think it was Colorado? How many of you think it was Pennsylvania? I know I gave you the answer, but let's figure out why. Although federal law governs the disability claim, the law is silent on whether there is a discretionary clause, whether it's enforceable, and under what law. The 10th Circuit said that the federal court should look to the state law, but in deciding what state law to apply, the court should be guided by federal law, and in this case, the goals of ERISA. The 10th Circuit rejected the 5th, 6th, and 9th Circuit's approach to resolving this issue. I think they were wrong. The court found that the goals of ERISA were to promote efficiency and uniformity, and to give weight to the terms of the plan documents. Since the plan documents said that the policy was governed by Pennsylvania law, the court held that Pennsylvania's choice of law provision was enforceable, and the court upheld the denial of benefits. This case says, contrary to 3 other federal circuits, that efficiency and uniformity is more important than a state's right to regulate insurance, prohibit discretionary clauses, and protect their citizens from dishonest insurance companies. It's a blow to state rights, and I think it was an unfortunate outcome for Ellis.